Stop recording me. Stop recording me. There are other inconsistencies here. She claims that she was injured on the forearm. Like I said, she pointed to other different parts of her right arm, the tricep and bicep, and there was no visible signs of injury whatsoever. You may call your first witness.
This time, the defense would seek permission to make a motion for direct verdict of acquittal.
Go ahead.
Thank you, Judge. It'll be brief. Thank you. Your Honor, pursuant to Michigan Court Rule 6.419 AC, looking at a light most favorable to the prosecution without weighing the credibility of the witnesses, it is our position that the trier of fact cannot find that all of the essential elements of the offense of domestic violence have been proven beyond a reasonable doubt. Mr. Kennard is charged with domestic violence contrary to MCL 780.81 subsection 2. Number 1, pursuant to the criminal jury instructions, the people would have to prove that Mr. Kennard assaulted Miss Bonnie Stewart. Number 2, that Mr. Kennard is her spouse. Pursuant to the criminal jury instructions 17.2A, the essential elements would be number 1, a battery is a forceful, violent, or offensive touching of a person or something closely connected with her. And number 2, the touching must have been intended by the defendant, and an assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended either to commit the battery or make the complainant reasonably fear an immediate battery. Your Honor, it is our position that the people have not met their burden. Factually speaking, and pursuant to the jury instruction, there is no evidence pursuant to 17.2A, there is no evidence of a forceful, violent, or an offensive touching on this record. The complainant admits to no injuries, no medical attention, no physical evidence of any touching, let alone a forceful, violent, or offensive touching. Your Honor, a forceful, violent, or offensive touching would have physical evidence of injuries. The complainant admits the entire alleged incident takes place on either audio of hers and his audio and video recording. So the court has been in a position to, at minimum, listen to the entire interaction. Specifically on his recording that the complainant objected to on the witness stand, he says, "Bonnie, you have twice lunged at me trying to grab my phone and screamed, 'I hit you.'" She replies on the audio video recording, "No, no." He's telling her to get away from him at least 24 times, both before and after any alleged assault. She threatened him, and if the court remembers, in a very calm voice, she says, "I'll call the cops." He tells her point blank on the recording, "I did not hit you." On the video recording, you can see he's still in the bed and she's still standing at the foot of the bed, insisting that he either communicate with her or provide him with his phone. And this takes place after the alleged assault. The second witness, Sergeant Canterbury, testified as a sergeant and a supervisor that he completes detailed written reports. The complaining witness claimed that, according to Sergeant Canterbury on the scene, that Mr. Kennard struck her one time on her right forearm. The forearm, he testified, is the lower portion of the arm. The complaining witness testified on direct examination when either the court or the prosecutor, the court or the prosecutor questioned her regarding the positioning on the arm or the portion of the arm where he's alleged to have hit her. She testified the upper area of the arm or the tricep. Lastly, Your Honor, the defense admitted Exhibit 2, Sergeant Canterbury's body-worn camera. After the fact, she asked Sergeant, please don't arrest me. After the fact, when the police are on the scene, she doesn't cry or become hysterical until her husband is being arrested for a crime that he did not commit. Thank you, Judge, for listening.
Any response?
Yes, sir. Your Honor, when considering the motion for the directed verdict, the court must consider the evidence in the light most favorable to the prosecution. Now, defense counsel did just lay out the elements for domestic violence. So in this case, we do have to prove that an assault and/or an assault battery occurred under the statute. And the prosecution did not need to prove injury in this case. And although we did not see any photos of injury, we did hear testimony about an injury. In addition, we heard testimony that the complainant was terrified of the defendant, Stephen Kennard, and he also saw body cam and police Sergeant Canterbury's testimony that he observed Miss Stewart afraid and blinking and darting her eyes, indicating that she didn't want to be heard around Stephen Kennard. Again, under the statute, we need to prove an assault and or an assault and battery. And whether
You know what? I thank you very much. Taking all the evidence in light most favorable to the prosecution, the court finds that a reasonable fact finder could find proof beyond a reasonable doubt. There is still testimony as to whether or not the defendant battered the victim. There was testimony from the victim that she was struck in the arm. There is a dispute, obviously, with regard to where that would have occurred. I acknowledge that there were no injuries. However, an assault and battery does not require an injury. So I'm going to deny the defense's motion.
Yes, Your Honor. May we call our first witness?
You may. Thank you.
Officer Luis Hartado. He's an officer.
you might open it up.
Okay, thank you.
I'm sorry, who is this officer? Who?
Last name spelled Hartado.
Oh, Hurtado. I believe it's Hurtado.
Sorry, Judge.
That's okay. All right, sir, you can come right up here, please. And I'm going to ask you to raise your right hand. You solemnly swear or affirm that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, sir.
Okay, have a seat, please.
Good afternoon. So will you state your name for the record?
Officer Luis Hurtado.
And are you a police officer with Roseville Police Department?
Yes, I
And how long have you been so assigned?
am. 4 years, I believe.
Okay, and on this particular day, 04/03/2026, did you respond to a scene?
Yes,
And was it on the street Canterbury?
yes,
Okay, and when you arrived on scene, did you have a body camera
yes,
recording both audio and video?
yes.
And you don't have a written police report in this particular case, is that correct?
I do not.
And Judge, may I approach, I would like to mark the officer's body worn camera as defendant's proposed exhibit 3.
You may approach.
Thank you. I am approaching you with what has been marked as defendant's proposed exhibit 3. And I'm not gonna play it. I just want to, do you see something on the screen there?
Yes,
Okay, and I can play it. I need you to identify, is that your name at the top?
it is.
Would that be your body cam?
It should be. Yes.
And it was functioning on that particular date and at that particular time?
Yes.
And Judge, I move for the admission of this officer's body worn camera.
Any objection?
No objection.
Defense 3 is admitted.
Thank you, Your Honor. When you arrived on the scene, did you encounter the complaining witness in this particular case?
Yes.
Okay. And did she, express to you what her desire was regarding the arrest of her husband?
I don't recall if she specifically said something to me. I'm sure she did say something to, my sergeant.
Okay.
Sergeant.
And with reviewing your body worn camera that has been admitted into evidence, refresh your recollection?
Yes.
Oh, thank
By the way, I record all these. I didn't this morning, but I told them to go on, so you're on YouTube for whatever it's worth.
Okay, thank you. Thank you. May I approach the witness again?
May.
Thank you. Or you know what, the microphone is here, so, well, I don't know. I'm gonna play 7 minutes at the 7 minute and 32 second mark.
Shorter to now, right now.
Slow down. Can you turn that up a little bit, please?
Sure. I think I'll do what the prosecutor did and stand by the microphone.
That's fine.
Okay, thank you.
You took the microphone to the speaker.
Like this?
Just bend it towards your iPad.
Oh, so sorry. Thank you. Did you hear her say that on your body worn camera?
Yes.
Did you hear her say, I don't want him gone, I don't want him arrested?
Yes.
Does that refresh your recollection, sir?
Yes.
Oh, okay. Now, did you have contact with another individual that was inside of the location?
Yes.
And who would that be?
It would be the, son,
Okay, and do you recall the son's name?
at this time, no.
And if I suggested Stewart, does
Yes.
that, it is Stewart, okay. And how old is Stewart, if you recall?
That I do not remember.
If I suggest to you that he's 3 years old, is that, would you?
Maybe I don't remember asking, but I may have.
Okay, no problem. And can we agree that you had communication with Stewart, is that right?
Yes.
And do you recall, Stewart making any volunteering any statements to you?
Yes.
Okay, and in fact, what did Stewart say to you when he volunteered?
Right before we were going outside,
Yes,
to go play with them, he said that mommy hit daddy in the face.
okay, I'm gonna play something for you.
So, yeah.
Did you hear that?
Yes.
Is that what you were referring to?
Yeah.
And so is it fair that you didn't ask that baby that question, did you?
No, I didn't.
Okay, so did the baby just voluntarily say that to you?
Yes.
Okay, I'm gonna play something additional. I want you to listen to it. This has been admitted, and then I ask you a question, okay? Was that you? Was that your voice asking, Stuart, and then what happened?
Yes.
Okay. Did you hear what he said?
No, I did not actually.
Okay, I'm gonna play it again. I want you to listen and tell me if he said, if you heard him say, mommy was yelling and screaming. So I want you to listen for it.
So what happened first?
Sorry, let me take you back, okay? This is a little hard. Now, hey, okay, it's fine.
What happened?
No idea? Okay. Happened after mommy hit daddy in the face? Who hit first? Was it mommy or daddy? Mommy hit daddy first. Okay. Were you watching the whole time? It is dirty. Yeah. Were you? Yeah, it does have poop on it. Were you watching the whole time or did daddy hit mommy first? Daddy hit mommy first?
Did you hear him say, I'm telling daddy? Yes.
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 Okay.
Okay, sure. Did daddy hit mommy first? Mommy did?
I'm sorry, Your Honor.
No, you got a drink one?
I missed it. Could you please replay that, the last 10 seconds there? Sure. Sure.
Okay, sure. Did daddy hit mommy first?
Nice.
Mommy did?
Okay. Okay. And so is it fair to say that that was your body worn camera?
Yes.
And that was your interaction with the young steward?
Yes.
Okay, and do you know how many times you asked him, did daddy hit mommy first?
A few times I did.
If I suggest 6, would you agree with that? Does that sound about right?
Sounds about right.
And each time you asked him, did daddy hit mommy first? What was his answer?
It was mommy first.
Thank you, I have nothing to do with it.
Direct, cross?
Yes. So, how long did you say you worked at, for the police department?
4 years I believe so.
And that's for Rosehill?
Yes.
And so I assume you had gone to, or done a lot of domestic calls in the past, is that right?
Yes, and I've done 7 to 8 years of police experience.
Is that total?
Yes,
And 4 years with Rosehill?
4 years, but
And when you arrived at the home on Canterbury Street in Rosehill, is that correct?
yes,
And when you arrived there, you didn't talk to, a man named Steve Dunant, did you?
I don't believe so. I just don't remember if I helped with the handcuffing or anything like that, but I don't believe that I asked him.
And so you didn't take any statements from him?
No,
And you didn't take any statements from anybody on Stewart that day?
no,
You went inside first, is that correct?
no. I went inside. I think second or third. Officer Tyler.
Oh, I apologize. I meant, was the first thing that you did, was it to go inside the house?
Yes,
And is that where you saw the child?
yes,
He was about 3 years old, right?
yes.
And did you then follow him out to the backyard?
I told him to go to the backyard just because of the situation going on. I wanted him away from everything, just in case.
So the majority of your conversation with the child was outside? Is that
Yes.
correct? And, you indicated that he voluntarily told you mom would hit dad in the face, is that correct?
Yes.
Did you ask him anything prior to that?
No. I asked him if, where his sweater was, his shoes, stuff like that, but nothing, to the case itself. Just making sure that he was okay.
Now, it's not typical protocol to speak to the toddler at a scene like this, is it?
Not without like the parents' consent.
And, you never confirmed his version of events, did you?
No,
And if you heard the recording, you asked him what happened after mommy hit daddy in the face, and he responded, because. Do you recall that?
yes,
Would you agree that that's not a typical response to a question like that? Objection.
Speculation.
Any response?
Your Honor, I think he can justify his actual knowledge. I mean, a child was saying because after a what question, this is actual knowledge about the response to that.
I'm gonna ask you to rephrase, sustaining the objection.
I can rephrase. So you agree, he said because, right?
yes,
And you agree that, at that age, the way he was speaking to you, he wasn't speaking like an adult, right?
that's correct.
So you would agree that he wasn't a reliable narrator of the events that happened, right?
In a way,
What do you mean in a way?
I mean, a child can definitely see things and repeat them, but I wouldn't say not reliable. It's just at the moment there, the victim stated what she wanted to do, and the offender never made a claim about her hitting him. Or at least that was the information that was given to me by my colleagues, just because I was the one actually making the arrest.
So you would agree then that you had information that the defendant never said he was hit, right?
Just gonna object to this line of questioning because prosecutor knows that my client has a detrimental right to remain silent on scene with police.
I'm gonna sustain the objection. If her, but, it's not on Fifth Amendment grounds. It's certainly on the basis that he would have had to have that information imparted to him by another officer, which would constitute hearsay. So unless you lay a foundation that there's an exception, I'm gonna disallow that question.
Understood, Ron. So in the recording you heard, you had asked the child, said, did daddy hit mom first? Do you recall that?
Yes.
And, you recall that the next thing that the child told you was daddy climbed up a tree. Is that correct?
Yes.
You would agree that that's not a response to the question you had?
Yeah.
So, and you would agree that saying did daddy hit mom first was a leading question, right?
Yeah.
And you never confirmed whether you never spoke to anybody else after that, right?
No, I did not.
And you never confirmed, Bonnie Stewart's side of the story, is that correct?
From the officer, I did. I believe so, from Sergeant Canberry, and but I did not speak about it.
You know, so you were never able to confirm that the child's version of events, is that correct?
That's correct.
I have no version.
Any redirect?
That child never said to you that daddy hit mommy, did he?
He never said that. Had that the dad hit mom first.
And no. He never said, period, first, second, third, or fourth. He never said daddy hit mommy at all, did he?
No.
And when he initially said mommy hit daddy in the face at the 11-minute and 25-second mark, he volunteered that information without you having to pose a question to him. Is that fair?
Yes, it's an exciting utterance. So yes.
Not fair.
All right, you can step down, sir. Thank you. You didn't have any other questions, right? You can step down, sir. Thank you very much. Any other witnesses?
Makes me so nervous. Yes, at this time, I would like to call Mr. Fandar to the witness stand. From our perspective, Judge.
Okay. Raise your right hand, sir. Do you solemnly swear or affirm that the testimony you will give in these proceedings will be the whole truth, so help you God?
I do.
All right, you may proceed.
I get your name for the record, please.
Stevie James Kennard.
And have you sat through the trial and heard the evidence in this particular trial?
Yes, I have.
Did you hit your wife?
No, I did not.
Did your wife hit you?
Yes, she did.
Judge, may I approach
Yes.
the witness? I'm sure, you know, I am approaching you with defendant's proposed exhibit number 4. 4, 5, 6, and 7. Defendants, can you identify what you see in defendant's proposed exhibit number 4?
That is my right bicep.
Okay, and do you see anything on your right bicep?
There's several bruises.
Okay, and can you describe for the court what you're wearing, that shirt that you have on there?
That's the shirt that I had on when I was arrested.
Okay, and when was this photograph taken?
That was immediately after I was released, after the civil stand, now I retrieved my belongings from my home.
And this photograph is taken inside of your home?
That photograph was taken at my mother's house.
At your mother's house, okay. And defense moves for the admission of defendant's exhibit number 4.
Your Honor, I'm gonna object. We have no way to authenticate this photo. It doesn't have a date, it doesn't have a time. We are solely relying on his testimony that it happened immediately.
That's subject to cross-examination. It accurately reflects how your bicep looked when you were released.
Yes, sir.
Defense 4 is admitted.
I am showing you what is marked as defendant's proposed exhibit number 5. Can you identify that photograph, sir?
That is my right hand, my index finger, and the inside of my knuckle.
And what do you see on that photo?
That's a cut on my inside of my on my finger.
Was that photograph taken at the very same time that defendant's 4 was taken?
That's the very same time, yes.
Move for the admission, Judge.
Any objection?
I'm gonna restate my single objection.
Does that accurately depict an injury that you received when your
Yes, sir.
wife assaulted you allegedly?
Yes, sir.
Defense 5 is admitted.
Thank you, Judge. I am showing you defendant's proposed exhibit number 6. Can you identify that photograph, please?
That's the first photograph you showed me?
Nope, I'm sorry.
Yes.
Is that a closer up
That's a
photograph?
closer up, yes.
Okay, and does that accurately reflect your arm on the date and time that your wife allegedly assaulted you, sir?
Yes, it does.
Move for the admission, Judge.
Same objection? Defense 6 is admitted.
Thank you, sir. Nothing further.
Cross?
Yes, sir. Yeah, please. Sure, you can. Well, that's okay. When I get out.
Okay.
So you were with Bonnie Stewart on April 3rd, 2026, is that right?
Correct.
And that day you had some kind of argument, not only with Bonnie Stewart, but with your ex-lady president in Ashley.
Correct.
And it was something about the custody of the children you have with Ashley. And so around that time, you were pretty frustrated about this argument that you had with Ashley, right?
Correct.
And following that, you then began arguing with Bonnie Stewart, is that right?
Correct.
There was a point in time, that you've heard from the testimony today. Following this argument, you went upstairs to your bedroom, right?
Yes.
And you have a son with Bonnie Stewart, and is that right?
Yes.
And at some point, he came to your room with some kind of ice cream sandwich.
Yes.
And you were frustrated and you kind of dismissed it, right?
Yes.
And Bonnie then went to talk to you about that, is that right?
Yes.
So,
Judge, I'm just gonna place my objection on record and then I'm gonna sit down. It is outside the scope of direct.
Yeah, it's cross.
I.
Overruled. It's overruled.
Now, you indicated to your counsel that, you were injured from that day, right?
Correct.
Now, when the police first arrived, did they arrest you right away?
2 minutes and then they arrested me.
You spoke to them prior to being arrested, right?
Brief, yes.
You never voluntarily told them that you were injured at that time, right?
Judge, I'm sorry, I'm just gonna place the same objection on the record. He has a right to remain silent when he is encountered by police.
Your Honor,
He does have the right to remain silent, but he wasn't in custody at the time, so I'm gonna overrule the objection.
Thank you, Judge. And just so that the record is clear, he said that he was arrested within 2 minutes.
I heard that.
Okay, thank you, Judge. I appreciate the court.
so you did speak to police prior to arrest, right?
Yes.
Again, you never told them that you were injured that day,
Before you were placed in custody.
Before I was placed in custody.
and you never told them, before you were placed in custody that Bonnie Stewart had hit you, right?
Correct.
And, it wasn't you that called the police, right?
Correct.
But you're indicating today that you were injured, right?
Correct.
And you didn't think to call the police after getting injured?
No, we're in the process of a divorce. I filed for divorce. We were working on our marriage and I don't want to see anybody be arrested. And we don't know who called or anything.
When did you file for divorce?
I filed in November last year.
So the divorce had been ongoing for about 5 months?
Correct.
And you two still living together
We
now?
were still living together.
So. You heard those recordings. In those recordings, you never at any point indicated to her that she hit you. Am I right?
Correct.
But at some point you heard her say that she said, why did you hit me? To you, correct?
Correct.
And in those recordings, you were pretty confrontational, wouldn't you agree?
Yes.
There was an argument, right?
Yes.
So you were pretty angry.
Yes.
And, again, at no point did you indicate to her or even to police prior to arrest that she hit you. Is that right?
Correct.
So, given that you're indicating that she had hurt you, you never left that day, did you?
No,
You could have left home, right?
I could have left home. Correct.
If she had hit you, wouldn't you have been placed in fear?
She stated she was reading.
But you didn't think to leave the situation,
No,
even though you were hurt.
correct.
I have no further questions, Your Honor.
Any redirect?
No, Your Honor.
You can step down, sir. Thank you very much. Call your next witness.
Judge, at this time, the defense rests.
Any rebuttal?
Rebuttal witnesses, Your Honor?
Yes.
I know, Your Honor.
Are you ready for argument?
Yes, Judge. Yes.
You can go ahead, whoever wants to. If you want to go get the victim, she's welcome to come in now. Go ahead, Ms. Holloway.
I think, looks like somebody else is doing
That's
that.
fine.
Your Honor.
Take your time. Do you want to take a couple minutes and gather your thoughts? If you do, I don't mind.
Most of it really care.
Okay.
Again, Your Honor, we had two people in our case in chief testify today. We had Bonnie Stewart and we had Sergeant Canterbury. Your Honor, Bonnie Stewart had testified that the defendant, Stephen Kennard, had hit her on the arm once with an open hand. And the Sergeant Canterbury also testified indicating that he arrived to the residence. He saw that she appeared to be fearful and that he wanted to take her outside to get out of the situation. Because of, based on his experience and knowledge, that she appeared to be afraid to speak in front of Stephen Kennard at that time. And after that, he did speak to her and she indicated to him the same thing that we heard today, that she was hit on the arm by Stephen Kennard. We heard recordings, first recording made by Bonnie Stewart, where at the end you hear some rustling and you hear, "Why did you hit me?" At no point do we hear that she hit Stephen Kennard. At no point was a statement made like that to police. And at no point did Stephen Kennard say that he was injured. The domestic violence statute requires that an assault and or assault and battery be made. It does not require injury. As you know, the definition for assault is for a reasonable person to be placed in fear of an immediate battery. And the definition for battery is for that forceful, offensive touching of another or something closely connected to that person. You know, we heard sufficient testimony today that she was placed in fear of, and she said herself she was terrified. She said she was terrified to even call the police in front of him. We saw a video and we heard from the officer of his observation that she appeared fearful. At the very least, an assault was proven beyond a reasonable doubt here, and we would ask that you find it.
Thank you.
Very quickly,
Sure.
the reasonable doubt, the burden of proof. They are the foundation for which our criminal justice system is so deeply rooted. Simply put, Your Honor, from a defense perspective, the prosecutor has failed to prove her case beyond a reasonable doubt. The beauty in this particular case is that the court was in a position to hear the entire incident from beginning to end based on the audio recording from the complainant and the video and audio recording from the defendant, Mr. Kennard. Your Honor, my client stands before this honorable court charged with a very serious offense. There was nothing based on her actions that were recorded on video footage from the police, the body-worn cameras, that would ever suggest that she was placed in fear of apprehension of an immediate battery. In fact, her actions suggest just the opposite, Your Honor. And as I indicated in my opening, initially to this honorable court, I indicated that she followed him, which would be indicative of her not being in fear of an immediate battery or an assault, that he kept saying, leave me alone, just go. And that she refused to leave him alone and just go. In fact, specifically on her audio recording that was admitted by the prosecutor, he said, go, leave. And she responded on her own audio recording, I don't want to leave. I want to be here with you, but you're not letting me. She continues to antagonize him. The court is able to see her standing at the foot of the bed, and this is after she makes the allegation of some kind of physical touching. In fact, Judge, the evidence is clear when she indicates to the officer on body-worn camera, please do not arrest me, because she was aware that she had had contact. I published this to the court.
Sure.
She was aware that she had had contact and had assaulted Mr. Kennard. And as a result, he sustained the injury, the bruising to the right arm area. She was confused, not realizing that, in 2026, everything is either video or audio recorded, and the video footage from Canterbury would establish that she had no injuries, that she indicated that she didn't even want to discuss that. When she indicated on the body-worn camera, Your Honor, please don't arrest me, to me that spoke volumes, because that was indicative of her knowing that she had assaulted Mr. Kennard. And then what I find more interesting than I have ever in all of my years is that the child, who is as sweet as pie and is innocent, volunteers to the officer and is captured on body-worn camera. It was the defendant's admitted exhibit. He volunteers His exact words were, "Mommy hit daddy in the face." The officer is doing his very best to communicate with this young child, and he asked this young child 6 times, and the child never wavered. He insisted that he was present when mommy hit daddy. And you know, Judge, I'm going to conclude this. Of course, I'm going to ask the court to find my client not guilty. But this is what troubles me, Judge, and I know it's Friday evening. Perhaps my client didn't have an audio or video recording of this particular incident. He might be differently situated. Perhaps Rose Hill Police Department didn't have body worn cameras. He would be differently situated as he stands before the court. But in 2026, thankfully, there is audio and video evidence that we as defense counsel can provide to this honorable court on behalf of my client to show that not only is he not guilty of this offense, but he was the victim on that particular day. And as the court knows, he's not obligated to give any information to the police. When the police come to the scene on a domestic and you have a woman that's moving her eyes and the police don't know, they weren't there. They can only give the information as it is given to them and based on their own perceptions, based on officers' experience. Based on officers' experience, they did the right thing in arresting him. Did they do the wrong thing? Ultimately, absolutely, because he was the victim. And Judge, I'm not a man. But me and her macho. And so I can't see my client saying to the police, "She hit me on my arm," nor was he obligated to do so. The fact is that the court has admitted the evidence to substantiate that he was the victim on this particular day based on the photographic evidence that was admitted. And with that, Judge, I would ask this honorable court, I know the court has been listening and I can see that the court is taking meticulous notes and we appreciate the court. I would ask the court to find my client not guilty. Thank you, Judge.
Briefly, Your Honor, in response to defense argument, again, the crux of the defendant's case is relying on the defendant and the officer Furtado. It's important for the court to consider the credibility of these two witnesses. First, the defendant submitting photos of injuries and even knowledge or any discussion of these injuries way after the fact. He had not told the police about any kind of injuries prior to arrival. He told nobody. There was no indication of him being in fear or of him being hurt in the recordings. And again, as for the officer, in his duties, not to deny the credibility in the course of his duties, but again, the credibility of who he spoke to. Like he spoke to the 3-year-old, he was relying on the narrative of the 3-year-old. He never confirmed the version of events that this 3-year-old had. And again, I would ask that he find the defendant guilty based off of the prosecution's evidence.
Thank you very much, both of you. All right, the defendant is charged with domestic violence. In order to prove this charge, the prosecutor must prove beyond a reasonable doubt each and every element of the crime. They must prove that this incident occurred on or about April the 3rd of 2026 in the township of Grosse Ile at 21615 Canterbury. Also, they must prove beyond a reasonable doubt that the victim and the defendant were married at the time. At least that is the allegation. There are others that would qualify, but clearly they were spouses at the time. Prosecutor also must prove that either an assault or an assault and battery was committed beyond a reasonable doubt. A battery is the violent, forceful, or offensive touching of the person or something closely connected with her. The touching must have been intended by the defendant, that is not accidental, and it must have been against the victim's will. An assault is an attempt to commit a battery or an act that would cause a reasonable person to fear or apprehend an immediate battery. The defendant must have intended to commit a battery or to make Bonnie Stewart reasonably fear an immediate battery. An assault cannot happen by accident. At the time of the assault, the defendant must have had the ability to commit a battery, or must have appeared to have the ability to commit a battery, or must have thought he had the ability to commit a battery. A person accused of a crime is presumed to be innocent. And this means that that presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless the fact finder is convinced that each and every element of the crime has been committed beyond a reasonable doubt. In this case, the facts are really pretty straightforward. We have the victim testifying under oath that she was struck in the right arm by the defendant. According to the police officer, when asked at the scene, she pointed to her forearm. When the court asked her in questioning, she pointed to her tricep. When the defense lawyer was questioning her, she pointed to her bicep. That is an inconsistency. The entire recording that supposedly captivated this assault was only by audio. There was no video. There was rustling at the end, and the victim testified, "Why did you hit me?" She continued to stay there, and Mr. Kennard, and when I say there, I mean upstairs in the bedroom, and it was clear that the two continued to argue. Mr. Kennard kept telling her, "Go ahead and leave, take your pillow." But at all times, it was pretty clear to the court that the defendant was videoing the incident. The victim testified that she did not know whether or not he was recording the incident, but then again said twice, at least twice that I know of, "Stop recording me, stop recording me." There are other inconsistencies here. She claims that she was injured on the forearm. Like I said, she pointed to other different parts of her right arm, the tricep and bicep, and there was no visible signs of injury whatsoever. This is really, as far as I'm concerned, on top of that, this is frosting on the cake. We've got a child here who's 3 years old that had just been scorned essentially by his father, in the sense that, and I don't mean scorn, but told, "I don't want this ice cream sandwich," and his feelings were hurt, and the victim testified to that. And yet a few minutes later, she's telling the police, "Mommy hit daddy in the face." There's no contrary evidence to support anything other than the fact that this assault did not occur. She also stated, "Please do not arrest me." I don't know why somebody would say, "Please do not arrest me," when they were the victim of an assault. So under no circumstance, honestly and truly, this is not a close call for me. There's no way the prosecutor proved her case beyond a reasonable doubt. You did a really good job, Ms. White.
Judge, I appreciate it.
And Ms. Holloway, you are going to be one remarkable lawyer. You've only been practicing how long?
Almost 5 years.
Well, you are going to be a really good lawyer. I love your demeanor, and I think you are going to be judge material. I find the defendant not guilty, and again, this is not really a close call. So
Judge, we appreciate
you're
it.
discharged,
Thank you, Your
and
Honor.
thank you.
In this courtroom, the judge carefully listened to every detail before reaching a decision. The court showed patience, fairness, and respect for both sides, while ensuring that accountability remained at the center of justice. The judge's words reflected the importance of responsibility, self-control, and respect for others. Rather than acting on emotion, the court relied on facts, evidence, and the rule of law. This case serves as a reminder that justice is not only about punishment, but also about protecting victims, encouraging accountability, and maintaining public trust. The courtroom once again demonstrated why fairness and law matter in society.
What started as a family dispute quickly became a high-stakes courtroom fight over a fortune worth millions. Attorneys clashed over claims of financial exploitation, secret transfers, and questions about Rex Thomas's mental capacity. One side argued immediate intervention was necessary, while the other warned against taking away a man's independence. The courtroom grew tense as the consequences became clear. This wasn't just about money, it was about personal freedom. The hearing reached a dramatic point when the court discussed the possibility of removing control of the estate from its owner. A decision like that could change a person's life forever.
What began as a normal morning commute quickly turned into a terrifying road rage encounter. A woman testified that a driver aggressively followed her off the highway, pulled alongside her vehicle, and pointed a gun in her direction. According to her testimony, the driver mouthed the chilling words,